A single judicial gavel has just echoed with the force of a seismic charge, threatening to redefine the limits of American liberty and executive power. Yesterday, from the conservative stronghold of the Fifth Circuit Court of Appeals in New Orleans, a divided panel of judges delivered a landmark ruling that grants the federal government a sweeping new authority, the power to detain without bail and without a bond hearing potentially millions of undocumented immigrants living within the United States. This is not a ruling about border policy. This is a ruling about the interior of the nation, about homes, workplaces, and communities. The case is Centro de los Derechos del Migrante versus ICE, and it has just greenlit the most aggressive expansion of immigration detention in modern American history. We are breaking down the 2-1 decision that has sent political shockwaves from the Rio Grande to the Capitol, analyzing the legal rationale that overruled decades of precedent, and projecting the terrifying human and constitutional consequences now set in motion. Act 1, the ruling, a doctrinal earthquake. Let's dissect the legal core of this bombshell. At the heart of the dispute is a Trump-era policy memorandum from July 2025. Issued by the Department of Homeland Security, this directive reclassifies virtually any undocumented immigrant encountered by ICE within the United States, a person who may have lived here for decades, as an applicant for admission. This is a term of art, a legal label historically reserved for individuals arriving at a port of entry, like an airport or border crossing. Why does this label matter? Because of a 1996 law known as the Illegal Immigration Reform and Immigrant Responsibility Act, or IRIRA. Buried in its text, Section 1226C states that non-citizens who fall into certain categories, including those applicants for admission deemed inadmissible, are subject to mandatory detention. They are not entitled to a bond hearing before an immigration judge. They can be held indefinitely until their removal proceedings conclude, which can take years. For decades, this provision was applied narrowly, primarily at the border. The Trump administration's 2025 memo sought to explode that limitation, applying it retroactively and universally to the estimated 11 million undocumented immigrants within the country. Lower courts across the nation, from California to New York, blocked it. 20 separate federal judges issued injunctions, calling it a gross distortion of the law and a violation of due process. But now, the Fifth Circuit has reversed those blocks within its jurisdiction. Writing for the 2-1 majority, Judge Edith H. Jones, a Reagan appointee, crafted an argument of stark textualism and executive deference. Her opinion makes two pivotal assertions. First, she argues the statute's text is unambiguous. The law mandates detention for certain non-citizens, and the administration's interpretation of who qualifies, while novel, is permissible. Second, and more profoundly, she dismisses decades of contrary practice. She writes that previous administration's choice to use discretion and provide bond hearings was merely a policy choice, not a legal requirement. The fact that prior administrations exercised less than full enforcement power, she contends, does not limit successors. In other words, past restraint is not precedent, it is simply weakness. This reasoning grants the current executive branch near limitless discretion to define the scope of its own detention powers. The lone dissent from Judge Dana L. Douglas, a Biden appointee, reads like a warning siren. She calls the majority's interpretation a radical reinterpretation that obliterates the fundamental distinction in immigration law between those at the border and those within the country. She focuses on the breathtaking scale. The government claims authority to detain 2 million non-citizens in the U.S. Interior, she writes, highlighting that this could include spouses, parents, grandparents of U.S. citizens who have built lives here. Her most searing critique is of the due process violation. By denying a bond hearing a basic check on government overreach, the policy creates an inadequate liberty deprivation. The only recourse for a detainee is to file a habeas corpus petition in federal court, a complex, expensive, and slow process utterly impractical for most detained individuals. Judge Douglas concludes that the ruling authorizes a system of indefinite detention that is both unlawful and un-American. Act 2, the immediate fallout, human cost and systemic collapse. This is not an abstract legal debate. The ruling took effect immediately, and its impact is visceral and quantifiable. Within the Fifth Circuit's jurisdiction covering Texas, Louisiana, and Mississippi, the very epicenter of the administration's deportation drive, over 150,000 individuals currently in ICE detention just lost their right to ask for bail. In Texas, home to massive facilities like those in Eagle Pass and Karnes City, 85,000 detainees saw bond release processes grind to a halt overnight. In Louisiana, at centers in Gina and LaSalle, expedited removals for 35,000 people are now accelerating, as the government no longer needs to justify continued detention. In Mississippi, the ruling empowers a new wave of workplace raids, echoing the trauma of the 2019 ICE raids that terrified communities. But this is just the detained population. The ruling's logic paints a target on a vastly larger group. Let's look at the numbers at stake as outlined in the court filings. The administration's own figures suggest the policy could ultimately apply to over 10 million people. This includes approximately 450,000 non-citizens with prior criminal records, who are now subject to immediate, non-negotiable removal proceedings. It encompasses over 800,000 individuals with temporary protected status or other pending claims, who now must fight their legal battles from behind bars. Most controversially, it targets an estimated 1.2 million long-term undocumented residents and up to 350,000 family members, including parents of U.S. citizen children, who face a renewed threat of family separation on a massive scale. The system is not equipped for this. Immigration courts already have a backlog of over 10 million cases. Detention facilities, many run by for-profit prison corporations like Geo Group and Korosevich, are at 100% capacity. The ruling promises a windfall for these companies, with occupancy rates projected to surge by 25% or more. Even as Texas scrambles to build 10,000 new detention beds, ICE has already requested an additional $8 billion to manage this expansion. The human cost will be measured in years of lost liberty for people awaiting a hearing, in families torn apart, and in a habeas corpus backlog in federal courts that could stretch for a generation. This is the machinery of mass detention clicking into gear. Act 3, the political war and the road to Supreme Court politically. The ruling is a thermonuclear event. President Trump hailed it on Truth Social as a massive win, declaring no more catch and release and vowing that deportations explode. For his administration and the GOP base, it is the ultimate validation of the America First immigration agenda, a potent weapon for the 2026 midterm elections, where polls show immigration as the #1 voter concern, giving Republicans a significant advantage. The Democratic response has been one of unvarnished fury. Prominent figures in Congress have labeled the detention facilities concentration camps and called for oversight hearings and even impeachment of DHS officials. The ACLU and immigrant rights groups, who brought the original suit, are preparing an emergency appeal. They will petition the Supreme Court for a stay, hoping to freeze the ruling's effect nationwide. This Fifth Circuit decision is not the final word, it is the opening salvo in a high-speed legal race. Similar challenges are pending in the more liberal Ninth Circuit covering California, and the Second Circuit New York. We are headed for a circuit split, where different appellate courts issue contradictory rulings on the same federal policy. This is a classic, guaranteed path to the United States Supreme Court. The Supreme Court's conservative supermajority will now be asked to resolve this fundamental conflict. Does the 1996 law truly authorize a mass, bondless detention of the domestic undocumented population? Or does the Constitution's guarantee of due process require a hearing before the government can lock someone away for months or years during a civil proceeding? This case will join a blockbuster docket already set to examine the limits of presidential power. On issues from tariffs to birthright citizenship, the Fifth Circuit has not just changed policy, it has set the stage for a defining constitutional showdown over liberty, sovereignty, and the very meaning of we the people. The Fifth Circuit's ruling is a pivot point. It shifts the paradigm from targeted enforcement to a system of presumptive, indefinite detention. It replaces judicial discretion with bureaucratic fiat. It argues that because the past government showed restraint, a future one is not required to. The dissent warns of a human rights crisis. The majority sees a faithful execution of the law. As this battle ascends to the Supreme Court, two Americas are being argued over in legal briefs, one where the law is a shield for community safety, and another where it is a warrant for unprecedented social control. The detention centers are filling. The appeals are being filed. The nation's conscience and its constitution are now on the clock.